to this computer. There we go. We're now recording. So over the coming months, we'll be hosting further events in the series, including an event with Leah Hochter, the European Director of the Centre for Reproductive Rights, which will be on reproductive healthcare in Northern Ireland, and Jeff Dudgeon of Dudgeon Against the United Kingdom fame, who'll be sharing his experiences in the fight for the decriminalisation of male homosexual sex in Northern Ireland. But just before we begin properly this evening, I'd just like to introduce and thank the new LILA committee for its hard work in introducing, or in organising, I should say, what's going to be a fantastic series of events over the next 12 months, and ideally our first meetings and events in person as soon as we're able to do so. I'm assisted tonight by our new secretary, India Fahy of BCLP, and committee member Oran O'Connor of Lookmany Thompson. Our new co-chair is the long-standing or long-suffering Will Glover of Three Temple Gardens, who many of you will know, and our treasurer is Anne Kavanagh of Irwin Mitchell. And our fantastic new committee is made up of Catherine Gilfetter of Denton's, Gerald Byrne of Brown Rudnick, Mark McCloskey of Debevoise and Plimpton, Thomas McGarvey of Church Court Chambers, Kerry McGuigan of Peter and Peters, Claire Nevin, a fantastic barrister in the making, and Michael Walker of Mishcon Derea. And by the way, I'm David Hardstaff. I'm co-chair with Will this year. And just on behalf of both myself and Will, again, we're just immensely grateful to the rest of the committee for their work, particularly during lockdown. As you can imagine, one of the best things about usually being on the LILA committee is the time we're able to spend together at events, getting to know each other, sharing a drink or two and talking about ideas and just, legal life in London. So very much looking forward to being able to do the same again in the not too distant future. Now, in addition to the Road to Rights series, which we're kicking off tonight, we're looking forward to relaunching our very successful mentoring scheme, which is aimed at partnering young and some not so young aspiring lawyers with some of the very experienced and talented practitioners that make up LILA's membership. There'll be more information on that to come over the coming weeks and months. But if you'd like to get involved either as a mentor or a mentee, please do get in touch and we'll provide you with some more information. Get in touch via contact at londonishishlawyers.co.uk or just through the website, and we'd love to hear from you. And of course, as soon as we're able to do so, we're looking forward to welcoming as many of you as possible to our second annual dinner. We were saying the other day that it's just feels very strange and very unusual that it's just over a year since we welcomed so many of you to our first annual dinner at Bentley's at the beginning of March. And obviously a lot has happened since then, but we're very much looking forward to getting together with all of you again and catching up over a few glasses and doing what we do best, which is just enjoying the rich community that we have here in London. And so back to this evening. As expats often absorbed by busy London legal life, it can be easy to lose track with developments at home. And one such development, which is gathering real momentum again, is the issue of a Bill of Rights for Northern Ireland. It's a fascinating issue with a wide range of implications for the whole of Ireland, and its mandate in earnest dates back to the Good Friday Agreement in 1998. 10 years later, in 2008, the Northern Ireland Human Rights Commission submitted its advice to the then Secretary of State for Northern Ireland, and our speaker tonight was one of the commissioners who prepared that report. Since then, the process has arguably stalled, although as Northern Ireland's constitutional future and place in the world is debated against a backdrop of Brexit and other developments, the issue of a Bill of Rights is perhaps more relevant than ever. The new decade and new approach deal, which paved the way for the Northern Ireland Assembly and the other institutions to be restored last year, called for further consideration of the creation of a Bill of Rights. And that work is now well underway by the Northern Ireland Assembly's ad hoc committee on a Bill of Rights. And so we're delighted to welcome Professor Colin Harvey of Queen's University to speak on the topic this evening. Colin's a professor of human rights law at Queen's University and a former head of the School of Law and director of the Human Rights Centre. He's held visiting positions at the University of Michigan, Fordham University, and the London School of Economics. He served as a commissioner on the Northern Ireland Human Rights Commission and is a member of the Northern Ireland Higher Education Council. He's a member of the academic panel at Doughty Street Chambers here in London, and a senior research associate at the Refugee Law Initiative at the School of Advanced Study and the University of London. He's spoken and written extensively on the topic of a Bill of Rights for Northern Ireland. And as I said, he was one of the commissioners to produce the 2008 advice. And earlier this year, indeed, he gave valuable evidence before the ad hoc committee on the same topic. And so it's fair to say he certainly knows his onions on this particular topic. So without further ado, I'm going to hand over to Colin. Hopefully this works. Bear with me. It's our first webinar. And I will let him take it away. So over to you, Colin.
Thank you very much, David. And thank you very much for that very kind introduction, and also for the invitation to be with you virtually this evening on a topic that has gathered renewed momentum, as you've rightly said, in recent times. And hopefully this evening we can have a bit of a conversation around that. So welcome the idea of a seminar series on the road to rights, because the Northern Ireland is very much still on that road to rights, and it's got a fair way to go on that road yet. So I suppose the focus this evening is specifically on the Bill of Rights process. But what I'd like to do also is to try and widen out the frame for the conversation this evening into the wider discussions that are happening around constitutional futures as well. What I'm going to do this evening is I'm going to cover three themes. I'm conscious that those listening, there'll be varying degrees of knowledge of the background of this process. So for those of you who are very familiar with it, just bear with me, because I'm going to firstly think about the context of what we're actually talking about this evening. And what I'd like to do is just sketch some background and give you a bit of information on how we got to where we are. Then secondly, I want to say something about where we are now. And finally, where I'll need your help is where next, because the conversation is very much live again. So first of all, then, I want to say something about background and context to the process. As many of you, all of you will know, in all the landmark documents of the peace process, human rights figured in Anglo-Irish Agreement, Downing Street Declaration, the framework documents. The Bill of Rights process here has a very long history. It didn't start with the agreement, it preceded it. If you even look at proposals, for example, from the Committee of Administration of Justice in the 90s, making proposals for a Bill of Rights. So it's a long-running process. But what we're talking about this evening owes its origins to the Good Friday Agreement, because the Bill of Rights process really gained intensity and momentum from that. And we all know the significant legitimacy and endorsement that agreement has. So the Bill of Rights that we're talking about tonight is a very distinctive process that is anchored in the Good Friday Agreement itself. The mandate for the process is contained there. And I'm sure a number of people listening this evening will know that every single word, full stop, every comma in the paragraph of the agreement has been pored over for the last 2 decades to try and work out precisely what was intended. The job of work was given to the Northern Ireland Human Rights Commission. So the newly established Northern Ireland Human Rights Commission was essentially tasked by the Good Friday Agreement and the Northern Ireland Act to give advice to the Secretary of State on a Bill of Rights to advise on the scope for defining in Westminster legislation rights supplementary to the European Convention on Human Rights, drawing upon international instruments of experience and to reflect the particular circumstances of Northern Ireland. And the language of that agreement, as I've mentioned, has been pored over ever since as to what precisely it means. And we can talk a bit further about that this evening. But the job was given to the Northern Ireland Human Rights Commission. The Commission launched the current Bill of Rights process on the 1st of March 2000 in joint events in Belfast and Derry. And if I tell you that a process that was launched in 2000 ended with the submission of advice to the Secretary of State on the 10th of December 2008, perhaps that gives you a clue and a hint as to some of the challenges that emerged along that road to the submission of the advice. The process had many significant markers along the way. For example, contributions and documents, important documents from the Human Rights Commission, but also from civil society as well. I want to mention one thing in particular that's significant this evening. During that extended process in 2003, the idea emerged that to try and unblock some of the problems that were being experienced and some of the difficulties and disagreements that were emerging, it might be an idea to establish a forum or round table to bring political parties and civil society together to sort of hammer out some of the details of all this. So as a result of the St Andrews Agreement, 2006, a Bill of Rights Forum was established in 2006 that brought civil society and political parties together with an international chair, as we are wont to do here. We always inflict ourselves on an international chair. Some of these processes, Chris Sidoti from Australia came in to chair this. That Bill of Rights Forum was really an attempt to try and unblock the process and come up with agreed recommendations that would help the Northern Ireland Human Rights Commission to formulate its final advice. That forum reported in March 2008. And if you look at the forum report, really what the forum report did was replicate and underline the extent of agreement, but also the extent of disagreement. It's worth pointing out that in terms of reference for the forum were to come up with agreed recommendations, but I think it rapidly became clear that it wasn't going to be possible for the forum to agree on recommendations. So it came up with a report that simply indicated at the end of each recommendation the varying degrees of support. That was then handed over to the Human Rights Commission in March 2008. And the Human Rights Commission decided to set itself a deadline of Human Rights Day 2008, the 60th anniversary of the adoption of the Universal Declaration of Human Rights, to finalize and submit its advice. So on the 10th of December 2008, and David has mentioned that I was involved in the commission, I was a commissioner at the time, the commission handed over its advice after a very extended process. The procedural and process background I want to raise this evening because it's important, because it flags up something that has endured throughout the process. That while the Commission and others and civil society organisations found there was often substantial cross-community support for progress on rights, that wasn't reflected in cross-party support. And really it's been political party disagreement that has hindered progress in this for a number of years, and not just in this area as well. So the Commission submitted its advice in 2008. The Commission wasn't unanimous. Two commissioners, Daphne Trimble and Jonathan Bell, commissioners who, it would be fair to say, from a unionist background, dissented in relation to the final advice. That advice is well worth revisiting, although 2008 seems a long time ago. The Commission worked very, very hard, I would say that, wouldn't I, to work on a set of proposals that both balanced the need to reflect the rights, equality and identity concerns of the two main communities in Northern Ireland, but also to build in a wider recognition of a broader human rights agenda as well. Now, the Commission's advice has sometimes been described as maximalist. Why has it been described in that way? Well, the Commission opted to include a fairly full range of civil, political, economic, social, and cultural rights in its final advice. While that view has some merit, I think what it has tended to do is downplay the extent to which there are people who were also disappointed that the advice didn't go far enough. So, what happened next? Well, to cut a very long story short, the Northern Ireland office responded, and the British government was rather sceptical about a significant number of recommendations from the Commission. Not all the recommendations, but a significant number of them. It had a consultation, the responses to that consultation that were eventually published. But in 2009, 2010, effectively the process petered out, if you like. It came to an end. So the Commission had submitted its advice. The British government had essentially rejected huge swathes of that advice in at times rather dismissive terms. And it was stuck. Why was it stuck? It was stuck because the government then and since really has pointed to the lack of or absence of cross-party support as a rationale for not advancing the process. So in terms of context and background, we have a process that owes its origins to the agreement that gave that task to the Northern Ireland Human Rights Commission. The Commission submitted its advice on the 10th of December 2008. In many ways, quite ambitious proposals, met with rejection from British government, rejection from, I have to say, unionist political parties, and has been largely stuck since then. So let's have a think now, secondly, as to where we are right now. I want to start by saying this, because this is contested in some quarters. It seems to me that there is an entirely reasonable expectation from the Good Friday Agreement that there would be a Bill of Rights for the North. To me, it is nonsensical to say that the references to the Bill of Rights in the Good Friday Agreement, combined with the extensive participative process of asking people what they would like to see, did not result in a reasonable expectation of the people of the North, the people of Northern Ireland, that they would see a Bill of Rights delivered. So I reject categorically the view that the process ended when the Commission handed over its advice and the government didn't proceed with that advice. Also, equality and human rights failures are continuing to fuel political problems here, in addition to the obvious problems they create for people here who are denied access to those rights. What I mean by that? What I mean by that is that failure to legislate for a comprehensive Bill of Rights for Northern Ireland has overloaded the political system on numerous occasions. It is no coincidence, for example, that some of the enduring problems within our society are fueled by these equality and rights failures. If you look at the collapse of the Assembly in 2017, although there was an obvious focus on the RHI scandal, it's quite notable the extent to which frustrations around the failure to progress and implement agreement and subsequent agreement promises around rights and equality fueled, if you like, those concerns and anxieties and worries about what the Assembly and Executive weren't delivering. Some of that was then reflected, as been mentioned, on New Decade, New Approach in January 2020, when we see in that document, if you like, a renewed interest and momentum around the Bill of Rights, reflecting, I think, that rights-based concern that fueled the initial collapse of the Assembly. For example, it's no coincidence that some of the language around the restoration of the Assembly and the Executive was language around the need for a rights-based return. So over a year later, I suppose a question we can ask ourselves is whether that rights-based return has materialized. Obviously, that was before the COVID public health emergency that we're currently in. Why has the momentum been restored? Well, as a result of New Decade, New Approach, we now have an ad hoc committee in the Northern Ireland Assembly that is currently working on essentially finding a way forward for this process. The committee is actually taking evidence at the moment, and myself and many others have already given evidence to that committee. It's due to report in February 2022, which is next February, and it's recently had a consultation, a process to try and gather views. The next Assembly elections are due in May 2022. And I think essentially now that's where we're at in terms of the current process, really fueled by the momentum that's building. We've also seen the rise of civil society campaigning around this process as well. As notable, for example, a campaign at the moment, Make Our Future Fair, is trying to build further awareness around the importance of the need for a Bill of Rights and advances in equality and rights more generally. In terms of where we are now in wider context, we are obviously aware that there's an independent review of the Human Rights Act ongoing, and a number of individuals and organizations have submitted evidence to that. We know the extent to which that has raised real anxieties about further undermining the Good Friday Agreement if there was to be any tinkering with the Human Rights Act, given how important it has been here, and people raising real concerns and anxieties about what might happen there. In terms of human rights developments, it's been very interesting to watch what's been happening in the devolved settings. I suppose Scotland at the moment being the most really remarkable example, where we've seen the report, I think it was last week, from the National Task Force on Human Rights Leadership, making some very, very ambitious recommendations about a human rights bill and human rights legislation for Scotland. We've seen the commitment in Scotland to the incorporation of the UN Convention on the Rights of the Child. And so in many ways, a very, very encouraging picture showing the way in which regional or devolved power can be used to advance equality and rights. We've seen the role that rights and equality debates have played in the Brexit discussion in terms of the withdrawal agreement, for example, but also perhaps one of the more neglected aspects of the discussion, the role of equality rights in the now very famous indeed Irish Protocol. It's quite notable that given the history of discussions of rights and equality here, there's very, very limited public discussion around Article 2 of that protocol and the no diminution commitment that's contained there in relation to selected aspects of rights and equality. And I think we're all watching very carefully in the years ahead to see how that is actually taken forward and implemented. And we know the ongoing work of the various commissions across these islands. One further thing in terms of where we're at now, I suppose one of the implications of Brexit, we were talking earlier, you know, if you take two constituent parts of your state out of the European Union against their will, don't be surprised if you ignite a constitutional conversation about returning to the European Union and about the constitutional future. So I think where we are now is that there's a very extensive constitutional change conversation happening on this island. And also we've seen the nature of the conversation happening in Scotland as well. And I suppose what's intriguing to me is what role the discussion around the Bill of Rights will play and what role the discussion around rights in general will play in the constitutional change conversation. Perhaps worth noting there that the Good Friday Agreement has the notion of equivalence, of effectively equivalent, at least equivalent range of protections uh, existing in the south of Ireland as in the north. And I suppose one of the points maybe flag up as an interesting question is that, does that mean essentially now that every gain made for human rights in Northern Ireland now levers that rights gain into the constitutional conversation about the future? And may that lead to a different sort of dynamic, some of which I think we're beginning to see in wider civic conversation as about the communities and individuals who might be thinking more carefully about the merits of a Bill of Rights. So I think where we are now is, and I've rambled through quite a lot of points there, but we have to reflect on the Bill of Rights for Northern Ireland, for the North, now in these wider contexts, because if we're going to have a sensible, coherent, credible conversation, we need to have clear answers around where the Bill of Rights fits into that picture. So third and finally then, where next? I'm tempted to ask you all, where next? I suppose the headline in relation to that is that obviously here is an ethno-nationally divided society, basically divided very, very sharply around national identity. The Commission, in its advice, tried very hard to build in to its recommendations reflections of all the various particular dynamics of this society. So where are things going to go? Well, in terms of where we are now, human rights and equality provision here is really a patchwork of bits and pieces, a patchwork bits and pieces approach to equality and rights protection. Uh, what's lacking here at the moment, both in relation to equality and in relation to human rights, is a comprehensive approach. Now, that might not necessarily be a good or bad thing. I'm not necessarily saying doing things in that sort of way is itself intrinsically problematic. But I think ultimately the approach is unhelpful when we're involved in the exercise in trying to advance awareness around human rights and equality. And for me, I think it's increasingly flawed and inadequate. In other words, I think we need a Bill of Rights, but actually we need to think also about what we're doing in relation to equality here as well. We also have to keep in mind that that frustration around the promises of the agreement and subsequent agreements is still there. The sorts of anxieties and worries around rights and equality that fueled and underpinned aspects of the collapse of the Assembly in 2017 are very much still there. And I think some of the promises that have been made in New Decade, New Approach, I think people are looking on anxiously to see those being realised. In terms of the current ad hoc committee in the Assembly, again, it's taking evidence, it's had a consultation exercise, but the levels of engagement it has been involved in have been limited, and questions have been raised, the extent to which that really is a broad and participative process. I think at the moment it contrasts very, very sharply with the sort of approach, for example, that's been adopted in Scotland that's led to the generation of the proposals that we've seen now. So is that really adequate? Also, for example, the ad hoc committee was supposed to be assisted by a panel of experts. That panel of experts has never been appointed. So question raised is, has that idea disappeared? Will that panel of experts ever be appointed? And how much value will that have now that we're so far down the road in the process having already started? My view would be that that panel of experts would have been incredibly helpful in terms of advising the committee, particularly around the approach it adopted to its consultation exercise and engagement exercise, but also in terms of the range of evidence and experience it was gathering in and views it was taking. Also to keep in mind as to where we go next is this is not a blank page conversation. Yeah, And worry I have about some of the current discussions is they're proceeding on the basis as if we're starting again. We're not starting again. I think we have to respect the agreement mandate. And so in some senses, the ad hoc committee process is stepping to some extent outside of that process. The agreement's quite clear, for example, as to how this should go forward. And so the work that's been done so far, not just by the Human Rights Commission, but by the Bill of Rights Forum, and the contributions that have been made by civil society here need to be taken seriously in this process. I think it would be utterly disrespectful to all the people who've engaged in this process since 2000 and before for that work to be neglected, not taken seriously in terms of what the current committee is doing. My view is that Northern Ireland still desperately needs the right type of Bill of Rights. And I say the right type of Bill of Rights deliberately. I think it would be remarkable to me if we weren't thinking ambitiously around human rights and equality proposals. Why would we want to adopt a second, third, fourth rate Bill of Rights for this society? Why not be ambitious for the future? But also, the tragic element is my view is that the Bill of Rights, if enacted, would have helped. Some of the problems we've experienced in this society since 2008 would have been mitigated if we had had the sort of Bill of Rights recommended by the Commission. For example, in the area of culture and identity, some of the concerns that were raised in relation to the Emma and Jake D'Souza case were spotted years ago by the Commission and by civil society. It's interesting to look back on the advice from 2008 and see some of those issues covered in the advice. In the last couple of years, when we've been worried about economic concerns trumping concerns about basic right to life and well-being of people, it's notable, for example, that the Commission recommended a right to healthcare in its Bill of Rights in 2008, an enforceable right to healthcare. In other words, a right to healthcare that you could do something about, that's justiciable. And for those who said that that was all wishful thinking and idealistic and naive maximalism, look at what Scotland is now doing and look at the sort of proposals that are emerging in Scotland. And I suppose a question, although their politics is rather more conducive than the politics of Northern Ireland is, if Scotland can make these advances, why can't the North do the same? So we're waiting to see what the committee will recommend next February, still doing its work. Will the committee propose legislation to the Assembly? Will it propose a process for way forward? Or will it simply be, as many fear at the moment, another restatement of the political stalemate, essentially between unionism and nationalism here over basic rights issues? Obviously, the hope is that the committee will find a way to propose a constructive way forward. But there is a lot of worry and anxiety is that what we'll see is a sort of restatement of what we know already, that the political parties disagree on some of this stuff and can't make progress. So just to end, you'll be pleased to hear there's renewed momentum around a process and work that's been ongoing for many, many years. Much work has been done. And what I want to do tonight is I want to honor and pay tribute to all the people who've contributed to that Bill of Rights process down the years, and that it's absolutely vital that those voices, those inputs, that participation is not forgotten and not disrespected in what comes next, because there are some great ideas that can form and shape part of what is in this Bill of Rights. But obviously, this evening, I've tried to sketch a framework. I've given you a potted history of where things are in context. But I suppose a question I would end with to people here this evening is hearing what you've heard, knowing what you all know about the process, is where does this go next? And essentially, how might we unlock this in order to ensure the passage of a Bill of Rights is finally ensured for this society, because it could sure do with one. Thank you all very much for listening. Thank you. I'll finish there.
Thank you, Colin. That's wonderful. Bear with me just a moment. Guys, I should have said right at the beginning, any questions we can deal with now by way of people being sort of patched into the webinar, or alternatively, we can have questions through the Q&A function. And if you can hear my dog barking in the background, I apologize. So bear with me just a moment. We'll go for the gallery view. Super. Colin, I had a first question for you. You mentioned this idea of trying to unlock the stalemate or the impasse that have been reached over the last sort of 10 years. I mean, obviously a huge amount of work was put into the process leading up to the Human Rights Commission's report in 2008. And one of the, it's perhaps a sort of overly simplistic question, but what do you think the difference is now in 2021 that would give you the confidence that this process is unlockable and can reach fruition?
It's a good question, and I wouldn't want to pretend that, and I wouldn't want to be over optimistic that we're going to see this process being unlocked now. I think it's good to see the renewed momentum, but at the moment, maybe to strike a slightly skeptical note, it's not immediately apparent to me that the political disagreements that have essentially impeded progress thus far have evaporated since the Commission submitted its advice. And a worry I would have, and I think you're right, David, is that there's a risk that the committee simply restates what we already know, is that main political parties, there's disagreement there. So I think it's also no coincidence that the remit in the agreement talks about legislation at Westminster. In taking this forward, I think there is more experience than we want to recount this evening in things getting stuck in the Assembly. The Bill of Rights isn't alone in relation to that. For example, I mentioned the protocol. Well, the protocol's got a rights and equality provision, but the protocols comes out of an agreement between who and who, the UK and the European Union, then enacted via Westminster. So I wouldn't want to give anybody a false sense of optimism around where this may all end up. I'd also just raise I suppose, slightly strategic question from a human rights perspective. Obviously, there's a government in Westminster at the moment that has been very skeptical about the Human Rights Act for some time, for example, was talking about repealing it and replacing it for many years, is now talking about updating it and is having a review. You know, how would we steer, let's say, a comprehensive rights and equality piece of legislation through Westminster at the moment? And what are the risks in doing that? This was one interesting sidebar question then, is looking at what is happening in Scotland. Is short of that, what are the options for making progress within the Assembly in terms of advancing some of these rights and equality questions? So I definitely don't want to give anybody a false sense of optimism this evening that this is necessarily going to happen anytime soon, unfortunately.
Thanks, Colin. We've got a question from Mark McCloskey. So Mark would like to know, in broad strokes, where the differences across political lines on the Bill of Rights lie. So is the threshold question the Good Friday Agreement's mandate for it? And what are the other key points of difference? And Mark, thanks you for the fascinating address.
Thank you very much, Mark. I'm going to do two things here, because the easy thing to do would be to point out the very, very traditional disagreements between unionism and nationalism here, right? In terms of, and I'll do that in a moment. But starting point, I think, is a more familiar issue around human rights, in that some of the debates here, why we like to think everything here is unique, are very familiar arguments about human rights and maximalist and minimalist approaches. So one of the themes in the debate here is simply that the Commission's advice went too far, that to do justice to critics of the advice, that the Commission exceeded its mandate, that the original intention of the agreement was perhaps for a few additional rights reflecting the particular circumstance of Northern Ireland, and the Commission's advice was simply too maximalist, including making things like socioeconomic rights justiciable, which, as you know, there's a debate around that. And for example, politicians, not just in Northern Ireland, but everywhere, have anxieties around aspects of that. I think some of that maps on to the traditional politics of this place. Like, just name it. The nationalist Republican parties here generally quite supportive of an ambitious set of proposals around human rights. The unionist parties here very skeptical around what was proposed, and so it split down those sorts of lines. What I tried to emphasize in presentation, however, is that when the Commission and when organizations like the Human Rights Consortium went out to talk to people and did polling, what was intriguing was the extent to which on issues like socioeconomic rights, there's cross-community support for those rights and their inclusion in a Bill of Rights. But the party politics here is very clear. And Mark, you know, and audience knows, historically, some of that's to do with perceptions around rights. So no matter how much this evening we say that human rights, the clue's in the title, right? They're human rights. And if we have a Bill of Rights, you don't have a Bill of Rights just for Colin Harvey. And no matter how much we say that a Bill of Rights doesn't belong to one community, one political party, or one individual, there's still suspicion about the language of rights here for historical reasons that I don't need to recite and that you're all very familiar with. I suppose a final element that poured into that discussion and that has emerged sort of periodically within unionism is the argument around a UK Bill of Rights. You know, one of the things I didn't mention in context there, that seems to have receded now, but you know, that was a big thing for a number of years. You know that the coalition government, you know, 2010 election, following that, set up a Bill of Rights Commission that gave advice on a UK Bill of Rights. And you know, there has been an argument within unionism, well, why do we need a special Bill of Rights for Northern Ireland? What about a UK-wide Bill of Rights? That's sort of trickling into now a wider constitutional conversation about whether the UK needs to get its constitutional act together. It's a sort of never-ending first-year undergraduate question, right? Should the UK have a written constitution with a Bill of Rights in it? Good luck with that would be my response at the moment. But it was interesting that when the UK Bill of Rights Commission did actually submit its report, although there was disagreement there as well, they were quite clear that whatever they were doing shouldn't stand in the way of a separate process for Northern Ireland. So I'm also very conscious this evening that I was on the commission that submitted advice. So all my my takes on this are slightly loaded with my own perspective on some of this, but trying to be as fair as possible to all different sides. My view on this increasingly is, and looking, for example, to what's happening in Scotland, is if you're going to have a Bill of Rights, why would you not want to be ambitious? Why would you not want to give effect to international human rights obligations that the UK has already signed up to internationally? And why would you not want to have a look around the world and follow comparative best practice? Why do the people of Northern Ireland deserve a second-rate Bill of Rights, would be my sort of thing. And I think it's really encouraging to look to see how Scotland, and to some extent also Wales, is taking this and running with it. And hopefully there are people watching that and seeing that you can use regional devolved power to do interesting human rights things, and maybe leave England behind on some of this stuff as well, and make advances. So.
Well, I think you're perfectly entitled to be a bit biased, Colin.
Yeah.
All very interesting points. Just on the UK comparison, we've had a further question from an anonymous member of the audience, which is, do you think the sustained attack on human rights in the UK increases support for a Bill of Rights in Northern Ireland?
That's a great question. There, as you know, here, I'm going to make the B word, Brexit, caused an awful lot of worry as to where the current government in London is thinking of going. Yeah, there's a lot of worry about the equality and rights impact of Brexit, and that the hostility to human rights is really profoundly problematic. I think practically you're seeing that in the responses to the independent review of the Human Rights Act, where people have gone to great lengths here, within the universities, across civil society, to make clear that the Human Rights Act should have a safe home here. That if it ain't broke, don't fix it. But more than that, that it's actually made a positive contribution to this place. I also feel myself that because human rights is a language that's anchored in objective international standards, it's also an important frame of reference for a divided society like this. And I think that shouldn't be underplayed. To be able to point to international standards, that the UK, that Ireland have signed up to voluntarily and are already, bound by an international law. I think that's a very, very helpful way of framing the discussion. But absolutely, very, very worrying attacks on lawyers, on judges, on human rights, and it really does need to be brought to an end, in my view, because it's been beneficial here. But also, finally, look, it's human rights and equality flow through the heart of the Belfast Good Friday Agreement. And we're already in a rather volatile place at the moment, to put it mildly, with what's happened around Brexit and the current discussions. So tinkering with the human rights framework, which, remember, is our starting point, right? The Human Rights Act is the floor of what people thought would emerge from the agreement, would, I think, be catastrophic for here, in my view.
Really interesting, thank you.
Colin, I thought it was interesting what you were saying about the equivalence issue, and constitutionally what that means for the relationship between the North and the Republic, and the consequences for the Republic of Ireland if a Bill of Rights was to be introduced in the North. I mean, can you say a little bit more about that, just in terms of the mechanics of it, because it seems like quite an unusual situation.
Well, there's two things to mention on that, and again, conscious that this may just be me. I've been involved in a lot of conversations recently around the constitutional future of this place, and discussions that are intensifying, and I think what they're encouraging is that when there's that level of potential future insecurity, it gets people thinking about human rights frameworks and the sort of security that they can bring. And even during my evidence session at the Assembly, I was really struck by comments that Mike Nesbitt made during that session about why there would be a rationale for embracing some of the protections that were in the Commission's advice, including around culture and identity and into the future. Second thing is that because this place is supposed to, constitutional status rests on not, essentially consent, it should make no difference in rights terms as to which choice people make. So you should enjoy as many rights protections in a United Kingdom as you do in a United Ireland. And that's part of the rationale for that equivalence notion that's in the agreement, that there should be at least an equivalent level of protection in any future constitutional scenario. Now, I've had debates with a few people around this, but to my mind, that means that gains made now in relation to this area will be and must be then levered into any constitutional change conversation as well. So my view on this is, if I was a strategic unionist thinking about the future and looking at what's happening here in terms of dynamics, and this is actually underpinned by research evidence about why people adopt these things around the world, it might be wise to dust off the Commission advice and have a look in terms of some of the guarantees that are there going forward. Also worth mentioning, of course, the agreement talked about a Charter of Rights for the island of Ireland, and that hasn't happened either. So, and also worth mentioning, underplayed is that the commissions on this island work together. There's a joint committee of the Human Rights Commission here and the Irish Human Rights and Equality Commission. And what's been really encouraging to see in the post-Brexit world is the way in which that joint committee is taking on a more prominent role in advancing discussions about rights on this island. So I don't want to overplay that, right? But I think it's an important, but it's also a reason why, the Irish government mightn't be overly keen on some of this stuff happening either, because it knows it's going to be picking up the tab down the line, perhaps in rights terms, if that's not a too crude a way of putting it. So.
No, that's interesting, yes, because you have issues then of sovereignty as well. And, when you're talking about some of the rights that were envisaged in the 2008 report, as you say, some of the wider socioeconomic rights, I can imagine that they are rights that are much more difficult to find a complete consensus on. And so I can see the sort of challenges you might experience there.
Well, maybe David, can I come in on that, because that's an interesting point, but it's also striking in the work that was done around polling and engaging during the process that it was actually on some of those issues that when you got beyond political parties and spoke to people about the sorts of rights they wanted to see in a Bill of Rights, it was housing, it was healthcare, it was about standard of living, it was a sort of bread and butter social justice type economic and rights issues that people actually wanted to see in that document across communities. And also worth mentioning as well, in the South, there's been a very extended debate since the Constitutional Convention and more recently about, putting socioeconomic rights in the Irish Constitution. And currently at the moment, a debate around a referendum around housing, for example. So that's a particular area where I think, people may be, particularly in a post-COVID world where we've seen just how important healthcare provision is, that people might be reflecting on, again, dusting off some of those recommendations around socioeconomic rights.
Really interesting. We've had quite a few questions flooding in, so clearly very engaging. So one question from Michael Walker for you, Colin, isn't the issue with the Bill of Rights that it's a very indirect way of solving any issues that Northern Ireland faces? For instance, rather than direct reform to deal with social immobility, a socioeconomic equality right to be applied would require a case to go through all the appeal stages, only for the ultimate best outcome being some kind of declaration of incompatibility, which lands you back at the same need for legislative reform.
It's a great question. My response to that is do both, right? So around the world, what you have is you'll have a Bill of Rights or a constitutional rights framework, in addition to specific and detailed legislative provision. So I would say to that, it's a great question, but do both. All a Bill of Rights will do, absolutely right, as human rights instruments tend to do. They're quite broadly, often quite vaguely drafted, and they're to be populated by much more specific legislative provision, and it doesn't stand in the way of that. But I do think this society, for a variety of reasons that you'll all be familiar with, could use a common framework of rights protection. I think it would do a lot of good here to have that common framework, albeit it will not. I am not one of these people in the world who thinks a Bill of Rights solves all the problems of society. It won't. I'm not arguing for ending up in courtrooms being the resolution to, like, in many ways this will help hopefully prevent some of those things happening. But I do think here a common framework of rights provision that takes some of the heat out of our politics would have been helpful, would have been a useful common framework of reference, and I think still would be very, very advantageous for this society, but in no way would have and will resolve all the problems we face, and detailed legislative provision will still be needed in all the relevant areas.
Great, thank you.
Question from Mike Meehan. The original working groups and contributions from civil society over the years to the proposed Bill of Rights resulted in very new and fresh conceptions and articulations of human rights. How much might this have provoked the reluctant response to the 2008 proposals by the UK government? And then he goes on, for example, in present contexts, a woman's right to be free from violence.
It's a great question. Like, one of the things I tried to underline in my presentation was to pay tribute to the work that was done, not by the commissions and not just by the forum, but by people who gave up their time and participated in the process. Because what I want to underline this evening is that this is not a blank page discussion. A lot of work has already been done. Keep in mind, in 2008, this was a Labour government. Yeah, this was a Labour government that rejected these proposals. It didn't reject everything. And again, worth looking again at the Northern Ireland office response, which highlighted a number of areas that it was willing to have the discussion about, but rejected a whole swathe of other areas where, as been rightly pointed out, there was a bit of imagination and a bit of ambition. On the point of violence, one of the proposals in the Bill of Rights advice for 2008 is a right to be free from violence, including sectarian violence, domestic violence, a very, very strong provision there, and a range of other robust guarantees as well. One of the things I tried to underline, and again, it's a good question. Look, my view is this would have helped. If we had have done this, if we had have got this in place, it wouldn't have prevented some of the things that have happened since, but it would have addressed some of the problems. Too many of these issues have become locked into the politics here and are stuck. And, the original idea back in the days of the agreement itself was that the Bill of Rights would take some of the heat out of some of this by having a standalone enforceable legal framework that individuals could use.
Super, thank you, Colin. I'm going to hit you with about 3 questions, sort of quick fire, if you don't mind.
Don't hit me.
Then,
no violence.
And then I'm conscious of time as well. So I'll go through these.
Yep.
They're quite short. So from an anonymous attendee, mysterious, what is the relevance of the Charter of Rights, also provided for in the Good Friday Agreement, for the constitutional conversation? And then on a very different topic, Thomas McGarvey, what is the least controversial area within the Bill of Rights regarding cross-community support? I think you've already touched on some of those socio-economic rights, but any others would be interesting to hear about. And then a final and fitting question from D. Smith: how can LILA members get involved in assisting on the Bill of Rights? And Dee's a barrister and ex-Northern Ireland resident. So that'd be great to hear, just if you've got any ideas as to how we can contribute as expats, as people with an interest but one step removed, how we can contribute to the debate.
Yeah. Well, thank you very much for all those questions. I'll try firstly remember them all, and then I'll try and answer them all. First point about the charter, one of the things that was given to the joint committee of the two commissions that I've mentioned was to come up with advice on this idea of a Charter of Rights for the island of Ireland. In June 2011, the joint committee, the commission, submitted advice around the charter. I'm not sure many people know that happened, that document is there, and that the commissions submitted that advice on the Charter of Rights for the island of Ireland. The document itself is rather a collation of existing commitments of Ireland and the UK, but it's worth having a look at in terms of what's proposed. But like the Bill of Rights, it hasn't advanced beyond 2011. My view on that would be that in the context of Brexit and what we're seeing now, that again, rather like other things this evening, that we could dust that off and have another look. Obviously, you'll all be aware that there's worry about divergence. If we have these principles like equivalence, if the North and South start to drift away from each other very, very radically, that's a problem. That's why, of course, we have Article 2 of the protocol. One of the reasons for Article 2 of the protocol is to try and mitigate and limit that in the area of rights and equality. But I think, again, the Charter and the Joint Committee could usefully have a look at that again. I think it would be useful to have that statement of principle, even, that in terms of the rights on the island of Ireland, particularly in the current context around Brexit. The question about disagreement and agreement, let me put it this way. One of the things I mentioned in the talk was getting the right type of Bill of Rights. Let me explain that. Maybe just of a personal reflection as somebody who was on the commission at the time. You have to make a choice, right, in terms of advice. We looked around the world, we looked at international standards, we looked at the remit, and we came up with, what we thought was a fairly credible set of informed proposals. But of course, you could orientate yourself completely along the lines of acceptability, right? And what I mean by that is this, that, you can take your steer in life by the question of what will be politically acceptable, right? So forget all those international standards, get what other people are doing. What will these people accept? The risk with that is you end up with a very, very unambitious, minimalist document that is or is not worth having, right? Or mightn't even deserve the title of a Bill of Rights. So you could pitch things very, very low and succeed. That's a dilemma I think that we all face, and it's true of the Bill of Rights. My guess would be, I'm just going to focus on political parties. My guess would be that if you came up with a set of proposals that were a couple, 2 or 3 or 4 additional rights that circled around issues of equality, culture, and identity, you might be able to secure cross-party support. I think what was striking to me about the parties is during the process, and this may be a personal reflection, on those sorts of issues, and it's also clear in the response from the NIO, on those sorts of issues, you could probably bank an agreement. But is that good enough, right? That would be my question. Yeah. So you might be able to get, and I think that's exactly the sort of dilemma that's going to face this committee. Now, it may be that in doing that, then you secure the agreement of the unionist parties. But of course, what's notable is Unionist and Republican Party have been very supportive of a more ambitious set of proposals. So, but my sense was that on those equality, culture, identity sorts of rights, there was, or you could have got party political alignment with governments. The risk is then you're dropping all the other stuff that when you went out to speak to people that they would actually want to see. Some of that's my own personal reflections of dealing with. And then you face that dilemma that I've mentioned. Lowest common denominator approach, and also just like you all know this better than me, right? I'm an academic lawyer, you're all proper lawyers, right? You're all real lawyers. Is that, when you're giving advice, how do you, we looked at the standards, we looked at comparative practice, we tried to give the best advice we could. We realized that goes down to the political machine after it. But very much we felt our job as a Human Rights Commission was to give them the best possible advice we can give them. Then they can wander off and reject it or do what they want with it. But, our job was done, and it would be almost compromising the name of what we're called, the Human Rights Commission, to do anything else. So anyway, that's just personal therapy there this evening for this group. The final question is about what can be done, LILA can do, and others. The committee is taking evidence. Why not offer to give evidence to the committee? Why not make a submission? Why not raise awareness? Why not have a further event or set of events around this? But perhaps at the moment, something, if you feel this is something that there should be here, then why not offer to give evidence? Why not come and speak or virtually to the committee? Why not make a submission? Encourage others also to join in that discussion, particularly your own organization, and the sort of insights that you bring to that will be invaluable. So, offer to give evidence, give evidence, make a submission, get involved in the conversation. I'm actually, like, you've asked me questions, I'll ask you questions. Some of us are just too enmeshed in this to see it, to see it clearly. What would unlock all this? What should be done? So please get involved, make a submission, see if you give evidence, share your thoughts.
And in a nutshell, Colin, what's the time scale for the ad hoc committee's process?
They're supposed
members understand.
They're tasked with submitting their report in February 2022. So that's less than a year, to do that. Then there's going to be assembly elections in May, so they give the report to the assembly. So that's unlikely to make progress there. It's notable in Scotland that the National Task Force submitted their advice last week, and Scottish Government is saying that after the Scottish elections, they're committed, if re-elected, to enact this human rights bill. But again, the difficulty is, to be very crude, the political environment in Scotland is much more conducive to making advances in this area than it is here.
That's brilliant, Colin. Colin, thank you very much. Thank you so much for your time this evening. I will probably suggest that we wrap things up now. I'm sure we're going to have questions afterwards. I can also see some people have been asking about follow-up details and in relation to that suggestion about making submissions. So that's certainly something that we'll look into and we'll put out to the membership.
Brilliant.
But we're just tremendously grateful for your time this evening.
Thank you.
And yeah, I mean, thank you for your valuable work on this very important subject. And it's been a long time coming. I mean, you've obviously dedicated a huge amount of your career to it, so it's very impressive.
Look, just want to thank you again for the invitation to speak this evening. Yeah, look, absolutely right. I spent a lot of last couple of decades or more working on this stuff. Absolutely, starting point for all this is this place deserves and needs, ambitious human rights protection. And again, I'm repeating myself, why would you want anything less for people here? People in the economic world go on and on and on about ambitious for investment, being ambitious for this, ambitious for the economy and business. Why would we not want to be ambitious for human rights and equality here, in my view? So, thank you.
I think that's an excellent point to end on. And that's certainly my take home from what we've discussed tonight. So just thank you to everyone else for joining us. Thanks for your questions. Great to see so many of you out virtually tonight. But as I said, hopefully before long, we'll be able to see you in person and catch up properly. And we'll be updating everyone in relation to the mentoring scheme. Do get in touch, and the other events that we're going to be hosting over the next few months. But that's it for tonight. Thanks very much. Thanks, Colin. And
thank you.
See you soon. Bye-bye.